Attempting to peacefully resolve a dispute constitutes generally an attempt at positive peace, whereby the disputants agree to end adversarial relations previously generated by conflicting claims. A genuine attempt at settlement goes beyond mere negotiations. The idea that states should resolve their disputes in a peaceful manner is critical to international security. Article 2(3) of the UN Charter requires that states settle their international disputes by peaceful means in such a manner that international peace and security, and justice, are not endangered. Chapter 6 of the UN Charter, which is specifically devoted to peaceful dispute settlement, lists these methods in Article 33. This article provides that the parties to any dispute, the continuance of which is likely to endanger the maintenance of international peace and security, shall, first of all, seek a solution by negotiation, enquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements, or other peaceful means of their own choice. In many international disputes, bilateral negotiations are attempted first as an antecedent to the more formal settlement venues. It is often quite useful to avoid unnecessary formalities associated with any third-party method, whether binding or non-binding. Negotiations are flexible and simple and incur low costs. Intuitively, it would seem reasonable to expect that only if negotiations fail to provide a solution will states subsequently use non-binding third-party peaceful resolution methods. Bilateral negotiations are not based on a fixed set of procedures. Negotiation is essentially an approach to conflict that is symmetric, equal, and voluntary. Negotiations entail discussions between the parties with the hope of reaching an agreement. Negotiations may be indispensable in finalizing the settlement even if an international court has issued a judgment. For instance, in the North Sea continental shelf cases, the parties, West Germany, Denmark, and the Netherlands, requested that the court merely specify rules of international law that would constitute an appropriate basis for the resolution of the dispute. After the decision, the parties settled their dispute via negotiations. Article 33 of the UN Charter lists the most frequently used methods of non-binding third-party methods, such as enquiry, conciliation, and mediation. When the contention centers on a specific question of law or of fact, enquiry can prove useful. A neutral intermediary is brought in to provide an objective evaluation of the situation and to inquire into facts and pertinent law. Inquiry can be undertaken by one person or by a commission. As a general rule, the objective of an inquiry commission is not to direct the process of reconciliation or agreement, but instead to focus on informing the parties of facts and laws. Good offices are not explicitly regulated in the UN Charter. Yet, this relatively informal method has repeatedly proved to be a useful means to settle a dispute. A good officer's task is straightforward: to motivate the disputants to begin communicating and maintain dialogue throughout the process of settlement. In contrast with mediation and conciliation, a good officer does not actively participate in the construction of settlement terms. Frequently, a regional organization provides its members with a forum for communication. The procedure and rules of conciliation have been codified in the 1928 General Act on the Pacific Settlement of International Disputes. Conciliation entails an intermediary producing a proposal, or a series of proposals that set out the terms of the settlement. In a way, conciliation has some aspects of mediation and inquiry, and historically, the process of conciliation emerged from treaties providing for permanent inquiry commissions. However, conciliation constitutes a relatively fluid framework, within which the disputants can pursue several options. As a result, a conciliation commission can be charged with a variety of responsibilities and tasks. In general terms, the aim of conciliation is to provide an informal framework of settlement for conflicts where facts and law are at the heart of the contention. The 1899 and 1907 Hague Conventions regulate procedures and rules of mediation. The UN Secretary-General, regional leaders, regional organizations, the Pope, heads of state, and diplomats frequently serve as mediators in many international contentions. Mediation is distinguished from other diplomatic methods in that it normally entails the active participation of the mediator in seeking to bring the parties together to further negotiations on the basis of the suggestions and the proposals the mediator will be advancing along the process, usually in an informal manner, and as the result of having identified and clarified with the parties their essential interests in the disputed matter. To this end, the mediator may elucidate and clarify the facts of the dispute, usually relying on the submissions of the parties, but not excluding the mediator's own findings, propose the terms of what would represent a fair settlement of the dispute in the mediator's understanding, and if successful, eventually help the parties with the implementation of the settlement. Via arbitration and adjudication, the two binding third-party mechanisms, disputes are settled according to international law. Decisions of arbitral panels and international courts are binding. In the process of adjudication, a dispute is submitted to a permanent adjudicative body, usually with a largely fixed composition. In arbitration, the disputants play an active role in selecting arbitrators. While both arbitration and adjudication entail formal procedures, the rules of arbitration are more flexible than those of adjudication. States have a high degree of flexibility in the composition of an arbitral tribunal. There can be a single arbitrator, usually a person highly qualified to issue a decision on the basis of international law. However, the most common form of an arbitral tribunal in modern state practice is a collegiate body consisting of either 3 or 5 arbitrators. The procedures involved in international adjudication and arbitration are relatively complicated. Both methods usually involve formal stepwise progression through different stages of proceedings. Comprehensive statutes and rules of procedure regulate the functioning of the various international courts and arbitration tribunals. At times, arbitration tribunals are asked to use the ICJ's rules of procedure, as was the case in the maritime delimitation dispute between Guinea and Guinea-Bissau. There are additional means of dispute resolution available to states involved in maritime disputes mentioned in the United Nations Convention on the Law of the Sea. Article 287 of the Convention lays out several choices of legally binding procedures includes International Court of Justice, International Tribunal for the Law of the Sea, Annex 7 Arbitration Panel, or Annex 8 Special Arbitral Tribunal.